All rise. First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Okay, good afternoon. Welcome to the First District Court of Appeal. We have two cases on our docket this afternoon, related cases, but not fully consolidated cases. We're going to take them in the order that they appear on the docket, recognizing that some of the issues obviously overlap in both cases, and we may go a little long on one or short on the other. We'll be flexible with the time to make sure we hear everybody out on this. Our first case is Harrison versus Department of Management Services, Division of State Group Insurance. That's 23-1674. Counsel, are you ready to proceed?
Yes, Your Honor.
And before we get started, would you like to reserve some time for rebuttal?
Yes, please, Your Honor. 4 minutes.
4 minutes, so noted. Thank you. You can proceed when ready.
May it please the court. My name is Michael Orr, and along with Katie Crowley and Kevin Cook, we represent the appellant, Arnold Harrison, who asks that this court reverse the trial court's order granting dismissal of the second amended complaint as to the department. We understand that there are a number of issues in the briefing for both cases, but for this particular oral argument and subject to the court's questions, we'd like to make 2 points and address 2 points for this appeal. First, the trial court did not exercise independent judgment in making its ruling in entering the order of dismissal. And second, the trial court erred when it dismissed the class allegations in the complaint without allowing class discovery.
Can you first identify which count has a prayer for relief against the department?
None of them do, Your Honor.
So why are we here with respect to the department?
They're a nominal party, Your Honor.
What does that mean?
So,
other than the obvious that you named it in the caption and nowhere else?
yes. Whenever there's a case and you're seeking relief against one defendant or one party, and they may claim that another party is an indispensable party, which Blue Cross has done throughout the proceedings, you can add a party as a nominal party that you're not seeking relief against them, but they're an interested party in the case and arguably an indispensable party according to one of the defendants. So there's no relief against them.
So, I mean, if we were to, affirm the dismissal, at least as to this count, does that have any negative effect on your client at all?
I suspect, Your Honor, what Florida Blue would argue to this court is that if we didn't have DSGI as a nominal party or involved in the case, that we would have failed to add an indispensable party. And so by this court's ruling, if it were to affirm and find that the state's not a proper party to the case and that they're not an indispensable party because whatever ultimate determination is made by the trial court would not be binding in some way on the state, then that we submit would foreclose the argument of from Blue Cross that they're an indispensable party. Because if Your Honor, in reviewing the record, will note, throughout all the arguments on the motions to dismiss, Florida Blue has taken the position that they don't have the right to do anything in this case, that the state is the insurer, that the department is the one that makes the decisions, that the department is the one that makes the findings. We certainly disagree with that, and those aren't the allegations of the complaint that's before this court. But that's the position that Florida Blue is taking.
But yet you went ahead and named them, so you were playing along. So isn't that a concession that they are an indispensable party, or that the department is an indispensable party? Like, how can you take the position that they're not an indispensable party, but name them as essentially as an indispensable party, as the excuse for not actually seeking any relief against them?
And Your Honor, for clarity, we haven't taken the position, because we haven't gotten to that point. Failure to add an indispensable party is an affirmative defense. There haven't been any affirmative defenses pled in this case. We haven't gotten to that stage yet. So my client hasn't taken a position one way or the other than adding them as a nominal party, as an interested party in the case.
But that is taking a position, because you're saying that they're an indispensable party. You just said that's why they're named as a nominal party, is because they're indispensable, or as a preemptive move in case they argue in an affirmative defense that they're indispensable?
Well,
I
I
mean,
think-
don't you have to take a position now?
Yes, Your Honor, and I think by virtue of our pleading, we've done that, and that's why they've been added. And certainly prior to this pleading and prior to the second amended complaint, Florida Blue has taken the position throughout all the arguments that the state is in fact an indispensable party and the one that's making the decisions. So based on the arguments that have been made by Florida Blue, who is the primary defendant in the case, we have added the state and included the state as a nominal party, which I believe we're permitted to do under Florida law. Yes, sir.
On the independent judgment issue that you had raised, Perlow and those other cases, most of those seem to be in a family law context or in some kind of fact-finding context. So if a judge adopts wholesale somebody else's view, one of the parties' views of the facts, I can understand how that can be problematic without some reflection. But on a motion to dismiss, couldn't the judge here have just said granted? Would have been a one-page order, motion to dismiss is granted, given us no rationale or reasoning, and that still would have been fine. And then both sides would sort through what the rationale and reasoning were. But there's different kind of judgment here. It's a legal issue as opposed to a factual issue, I guess is what I'm trying to get at.
And Your Honor's raised a couple different points, and I think first and foremost, I'd agree with the court that some of the cases are summary judgment cases or family law cases where the court's making findings of fact. In this particular case, the trial judge below did in fact sign orders in DSGI or the department's order that was 9 pages without making any edit whatsoever. And the Florida Supreme Court has set forth that test and didn't state in Perlow or any of its progeny that it only applies in summary judgment cases. In fact, some of the cases deal with the cases relied upon by the department. The Cole-Taylor case is in a setting where Judge Foster in Nassau County had a bench trial and had previously entered a summary judgment. And the court went back and looked at some of the prior rulings of the court and the ruling of Judge Foster from the bench trial and applied the same analysis to the summary judgment proceeding as it did to the bench trial proceeding. And so our position, Your Honor, is simply that the factors that the Florida Supreme Court has set forth and that the courts apply in the King case that we cited in our brief and all the cases apply, those are the factors the court must apply here when analyzing whether the court exercised independent judgment. And I think it's more of it's important in the context of once the court starts reviewing the 9-page order and sees what the court did. In this particular case, Your Honors, the trial court issued an order and said on page 1500 of the record that the court cites to paragraph 39 of the second amended complaint, and we address this in a footnote in our answer brief, and finds that, quote, the grandmother paid $96,950 of RH's residential stays, with a citation to paragraph 39. The entirety of the second amended complaint says nothing about $96,950 or a grandmother paying anything. That's just what the state injected into the proposed order that they drafted because that's their theory of the case and why we're all here, because they continue to suggest that that's the basis of the complaint and that's what's being sued for. And there are multiple errors where the trial court kept citing to paragraphs in the second amended complaint in its order that it signed that was submitted by the department. And those paragraphs don't stand for the proposition that the court finds those paragraphs state in the order. And so when those types of errors are made, that's what I think highlights the issues with not exercising independent judgment and why the Florida Supreme Court set forth that test.
Is it fair for us to consider how engaged Judge Marsh was during the proceedings? He talks about receiving some pre-hearing submissions, I think 2 binders, asked questions throughout the proceedings, seems pretty engaged and pretty aware of the issues. Is that a fair consideration in determining whether he exercised independent judgment?
I would answer that 2 ways, Your Honor. Rationally speaking, I would say that for any trial judge to be engaged at the hearing, it makes sense that they were in fact engaged. But the question that the court employs on independent decision-making doesn't focus on what the court said at the hearing, except if the court is instructing the parties and informing the parties as to its decisions with respect to either findings of fact or conclusions of law. Here, the record is completely devoid of that. There is no instruction from the court other than telling the parties, submit your proposed orders in Word, and I'm advising you now that I may take some from one and some for the other, but it's not going to be essentially what he did, a wholesale adoption of one or the other. So the factors that the Florida Supreme Court laid out, Your Honor, and Perlow and its progeny don't address that discussion of, well, is the court engaged in asking questions at the hearing? It focuses more on the judgment. Are you informing the parties of what your rulings are? And if you're not, that's fine, that happens. If you're taking proposed orders, one of the factors is, are you giving each side time to object to each other's orders? Well, here you're talking about a day and a half time period from the time the orders were submitted to the time they were signed. So there was no time to object. And then, again, Your Honor, with all the errors that we have, the cases that are relied upon even by the state in their brief, the Cole-Taylor case from this court and the Bishop case from the Second DCA, we think highlight this issue in the arguments. In the Cole-Taylor case, the first DCA was dealing with the opinion or the order that I referenced earlier from Judge Foster. Judge Foster actually wrote a letter to the parties after the hearing, telling them what his findings were and asking them to prepare a ruling. And there was an actual finding by the court that there was no basis to argue a lack of independent decision-making because there was an opportunity to object to the proposed orders.
How could there be an independent, I mean, why are we even having this discussion in the context of a legal determination, an assessment of the pleadings? As Judge Bilbrey just said, he could have said nothing, and we'd still be on review and assessing whether he was legally correct. And as you're answering that, can also tell me, going back to the nominal party question, let's say your complaint is allowed to go forward in the trial court, and both parties, Blue Cross and the department, remain as defendants. What would be the effect of a judgment against, I guess, just Blue Cross Blue Shield?
The Blue Cross Blue Shield would be subject to the judgment. And
well, what about the department?
well, the important piece of that, Your Honor, is we're not asking for any judgment against the department. So there's nothing that we're asking the department to do. The relief that we're seeking is to stop Florida
Right.
Blue.
And this appeal has to do with the order dismissing the complaint against the department.
That's correct, Your Honor.
And I think it's arguable that you haven't filed a complaint against the department. Just naming someone in the caption is not suing an entity or a party. And if you're not seeking any relief, you're not seeking any judgment, then what is the harm that was caused by the dismissal of a party that you're not seeking relief against?
Your Honor, I don't necessarily disagree with anything the court just said. I just know that a longstanding practice in the state of Florida and Florida law allows for adding nominal parties to cases when they
Is that a
have an
statute,
interest.
a rule? The Florida Supreme Court has said that you can just name someone and not seek relief?
No, Your Honor, I'm not aware of a case that
Right.
says that.
It's just lawyers do it, and no one's questioned you on it before.
Certainly would love to see an opinion addressing that issue,
Well,
Your
along
Honor.
those
but-
lines, why isn't the department's immune? Like, why isn't sovereign immunity bar anything against the department at this point?
Your Honor, that issue is not raised and is not subject to this appeal and is not briefed by the parties.
But it's the same thing as arguing exhaustion of administrative remedies. That's what in reality, that's what that is exhaustion has to do with the legislature authorizing a suit against itself and specifying where that litigation is going to happen. There hasn't been any authorization, as far as I can tell, for a suit to be filed against the department with respect to insurance. Can you identify something that says otherwise?
Again, Your Honor, that wasn't an issue briefed or argued by the parties. The argument on exhaustion of administrative remedies raised by the state was simply that Florida Blues argued, which is by virtue of the case going in front of the administrative law judge and having certain arguments raised and addressed by an administrative law judge, that not appealing that decision was a failure to exhaust administrative remedies. So that argument's not before the court.
Except that
And
it
not
is.
briefed,
I mean,
and I
it's not
certainly would
mentioned.
love to brief that issue, Your Honor. But Your Honor makes another good point, and I know Judge Bilbrey was getting to this as well. So why are we here if we're just dealing with independent decision-making? It's not just that. And I know there are cases out there that suggest that if they find the factors that the court didn't employ independent decision-making, they send it back. But here we've got more than that, and that's the second issue that we've raised, which is the court dismissed all the class action allegations that were pled in the complaint on an order on dismissal. And when we raise under Rule 1.220, the court can't do that. There's supposed to be a hearing, you're supposed to allow for discovery.
Well, but as it relates, and I know we're about through all your time, including your rebuttal time, so we'll give you some more time, but as it relates, at least to the department, if you don't have a claim against them, how can you be a class representative for no cause of action?
But that's the interesting point, Your Honor, is the state is making the argument really on behalf of Florida Blue that we shouldn't be able to bring the class claims against Florida Blue. I see that my time has expired, Your
Sure.
Honor.
And why don't we add 5 more minutes to your side and 5 more minutes to the state or to the department if they need it? And
Then I appreciate the time, Your Honor, and I'll take 1 more minute, and then I'll cede the rest of my time for rebuttal. The case relied upon in the brief by the state is the Mills case. And what the state says, what the department says, is, and this is on page 31 and 32 of the answer brief, they say to this court, certification was not appropriate even if Harrison proved his allegations, and that class discovery is not required in such circumstances. And they cite the Mills case, but Your Honor, Mills does not support their position. Mills says exactly what we're saying to this court. Mills, the 11th Circuit, reversed a district court for dismissing a complaint at the pleading stage and dismissing the class allegations and not allowing for the discovery and the hearing that's required. And that was under Rule 23, which is parallel to the Rule 1.220. And also under Rule 1.220D1, that there is a process that should have been employed by the court before dismissing a complaint containing class allegations. And we'll save the rest of our time for rebuttal. Thank you, Your
thank you.
Honor.
We've added 5 minutes to the department's time. You were asking earlier in the motion for just 10 minutes, so don't feel compelled to use all 20. But you have it if you need it.
Thank you, Your Honor. May it please the court, my name is Viveka Sapaya, and I will argue on behalf of the Department of Management Services. Today, we are here because appellant has taken advantage of this court's ruling in Harrison 1 to repackage claims that have failed time and time again. To affirm the trial court, this court only needs to focus on 2 issues. And the first is the standard for reversing a trial court's order, and the second being appellant's fundamental failure to exhaust administrative remedies. Your Honors, before I delve into the 2 issues, I want to talk about the history of this case. This case was born nearly 10 years ago in 2015 after appellant's daughter received treatment at a facility outside of Florida Blue's provider network.
Can you jump ahead and address why isn't the department claiming that it's immune from suit? Or should I say, why it's not claiming it's immune from a non-suit against it? Because apparently the plaintiffs are not seeking relief against the department.
Your Honor, the department is not immune in the sense that even though opposing counsel has said that they're really here today to bring suit against Florida Blue, they even concede that they're required to name the department as a party because according to Chapter 120, the department is the one that is the final arbiter on this on this issue today. And
Where
Florida
does it
Blue,
say that in Chapter 120 specifically?
Florida Statutes, Chapter 120.123, subsection 5, Your Honor, discusses the processes for an administrative hearing, and talks about how a contractor like Florida Blue that has contracted with the department is only responsible in terms of being a plan administrator. And that's why even at the administrative level, when appellant brought their claim for medical coverage, any decision made by the administrative law judge there was also binding on Florida Blue. And that's why Florida Blue...
How is that? I mean, we're getting a couple layers in, but maybe we can jump ahead to how an administrative law judge in the executive branch can issue an order that would have any effect outside the executive branch and be binding on the judicial branch. Which is what you're saying by arguing that the ALJ's order or the department's final agency action has res judicata effect in the trial court. So how could that be?
Your Honor, the administrative framework laid out in Chapter 120.1235 is a full adjudication. So their appellant did have an opportunity to litigate the issues in terms of not only a denial of medical coverage for his daughter's stay, but also these other issues. And I know that appellant is making the arguments that adding claims such as negligence, negligent misrepresentation, and breach of fiduciary duty are completely different and save this case from res judicata analysis. But the reality is none of the questions required for negligence, negligent misrepresentation, or a breach of fiduciary duty, we can't ask any of the questions there without asking the first question of was denial of medical coverage proper. And so since that was already litigated at the administrative level, not only is the department bound by that judgment, appellant bound by that judgment, but Florida Blue as a privy is also bound by that judgment.
I don't understand what it means to be bound. Like, how can a trial court be bound by the executive branch and administrative hearing officer? That's my question. I mean, it's an administrative order, so it's related to, I guess, that they've claimed a public right in some way or a public benefit through state insurance. And I understand you go through the department because the department, through the division, administers the program. That's fine, I get it. And they've gone through that. They've gone through the entire process. They got an order. An order says no. That's all well and good. To argue that that's res judicata and in some way binding outside of the executive branch seems to be a separation of powers problem. And I'm trying to understand why the department continues to argue that an administrative hearing officer's order has any effect on the exercise of judicial power by a circuit court judge.
Your Honor, I think that that's because this argument is being made in terms of res judicata because that finding of the denial of medical coverage at the administrative level still travels with this case at the trial court level. So
Why? Based on what?
According to Florida statutes, Your Honor, and the power given to the department to adopt this order as a final order, and Florida statutes giving the department that status of being the final arbiter here on the question of whether the medical claim coverage was proper or denial was proper. That is what, so from the legislature really is where the department gets that authority.
Right.
And
The legislature said that really through just generally Chapter 120 and without because it did not make an exception and say that you can be sued in circuit court over this, that the legislature said that your sole avenue to seek relief with respect to this public benefit under state insurance is through the administrative process.
Yes, Your Honor.
So in other words, aren't you immune from suit in circuit court because the legislature has not waived sovereign immunity, which it has to do before the department can be sued?
Yes, Your Honor, but since appellant is trying to bring suit against Florida Blue here as well.
But that's not this appeal, that's the next
No.
one.
That's correct, Your Honor.
But what's the department's position, though, as to whether it should even still be, assuming that there are some viable causes of action against Blue Cross that we'll get to in the next appeal, but even if there are, why should the department stay in the case?
Your Honor, I think the best authority here to answer that question is the AMEC 1 case, AMEC Civil LLC versus State of Florida, which there the contractor is in the same position that Florida Blue is in with the department today. And as a subcontractor, as a privy, we travel together in this case and have been traveling together for since 2018.
Well, and I guess my question is more what Judge Tannenbaum and I were asking early on your opponent. Why there's no damages, no remedies being sought against the department. So should the department remain in the case? I understand that you claim privity with BCBS and that y'all should travel together, and the issues of res judicata and the contract and all of that relate to both of you equally. I understand that. But why should you even be in the action at all if there are no damages, no remedy, no injunction, nothing being sought against the department?
DMS should remain in the sense that as a privy, Florida Blue, and as a third-party administrator, really, Florida Blue is really just administering the funds that are in the hands of the department. Requesting relief from Florida Blue when Florida Blue is only a third-party administrator, and really applying these criteria to administer funds that are in the hands of the department.
Why can't Florida Blue make that argument then? Is that they shouldn't be, I mean, I think they are making that argument in the next appeal, so.
Yes, Your Honor.
But it sounds like the department doesn't trust Blue Cross to make that argument, so the department feels like it needs to come in and make the better argument of the same thing. Is that the position of the department?
No, Your Honor.
So then why does the department need to be in the suit? Unless, wouldn't the better approach have been for the department not to be sued? And if you're concerned about any issues or interests of the state being litigated, you seek to intervene. And if it's granted, well, guess what? Now you're really a defendant, and you're named in one or more of the counts, I guess. And
Yes.
then you can litigate.
Yes, Your Honor, that would have been another way to approach, but as this case was not consolidated at this level, and we were also named as a party by appellant, we're here litigating today.
Named as a party nominally in the circuit court. And no one has still yet explained what the significance is of having one's name in a caption in a lawsuit. How is that even, I mean, that doesn't even call or invoke the exercise of judicial power against a party. I'm not even sure there would be personal jurisdiction if such a thing existed, with respect to the state. But it's just very confusing as to what this lawsuit is all about. So we have the appellant saying, well, we feel like we needed to name the department as a party because we were afraid that they were going to argue that they were indispensable, or that Blue Cross was going to say they were indispensable. But we're not going to seek any relief against them. And then we have the department saying, well, yeah, we should be a nominal party. We should be in the case. But we're fine, not having any relief, but we're still going to litigate on appeal. Can you explain what this litigation is all about with respect to the department? If the judgment ultimately would have no effect and not be binding or anything with respect to the department?
Your Honor, I think it really just goes back to the relationship between Florida Blue and the department, and the reason that appellant named the department even in a nominal sense is because of that fear that they would later be required to add it back in as an indispensable party. But before I also want to address, Your Honors, the first point that appellant made today in terms of Judge Marsh's lack of independent judgment being a reason why the order should be dismissed. They're taking the four-factor test from the King versus Farah and Farah case, and although appellant did not specify what exactly these factors are, they are the length and detail of the proposal, whether the parties were given any opportunity to object to each other's submissions, how long it took for the trial judge to adopt the proposal, and whether the trial judge made findings of fact and conclusions of law on the record to guide the parties' preparation of their respective submissions.
It seems like most of those would weigh against the department, right?
No, Your Honor. Of these factors, appellant only specifically takes issue with the length of time it took for the trial judge to adopt appellee's proposed orders and the fact that adoption of the orders was verbatim. And the factors do not create a bright line rule that orders adopted verbatim should be reversed, nor do they state that a proposed order must be considered for any given amount of time before being accepted. The reality is Judge Marsh's verbatim adoption of appellee's orders came after thorough research into the record. I know there was a question asked of whether or not Judge Marsh's engagement during the proceeding should be considered, and it should, because that is part and parcel of guidance that Judge Marsh is giving to parties in terms of preparing their submissions.
Isn't saying that the judge researched into the record cut against the whole point of what a motion to dismiss is? Shouldn't his engagement been limited to reviewing the complaint, or the Second Amendment complaint, and determining whether it states a cause of action?
In terms of exercising an independent judgment, Your Honor, engaging with the record, asking questions, which is what Judge Marsh did during this proceeding, is just evidence of being of a judge that is exercising independent judgment. Which even after asking these questions, being able to go back to the complaint and say, hey, this is not sufficient, that is still, again, an independent exercise of judgment. Your Honors, I know that appellant cited a couple of cases, the Perlow versus Berg-Perlow, West versus West, and King versus Farah and Farah. And in all of those cases are distinguishable from what we have here today, because there the trial judge either actively discouraged one side from submitting a proposed order, did not allow each side to see the other side's proposed order, or did not solicit a proposed order from one side, period. And here, Judge Marsh gave ample opportunity for appellant to make their case and objections. And that's evidenced by the fact that of the 6 proposed orders collected, 3 of the orders were from appellant. And appellant even exercised a motion for rehearing, which was duly denied by Judge Marsh because appellant could not specify exactly which provisions of Judge Marsh's adopted orders contained conflicting information or inconsistencies. And they mention an inconsistency today about the amount of money that was requested by appellant, not being there in the SAC.
Can I ask you about the motion for rehearing? The motion for rehearing that was filed in the department's case did not mention the law of the case issue that is raised in the Blue Cross Blue Shield motion for rehearing. Is that issue then, which I think is one of the first issues in the briefing here, is that issue preserved?
Yes, Your Honor, because it still travels with the fact that it still travels with the department's point on failure to exhaust administrative remedies. The denial of medical coverage still travels with these claims.
What is the, well, first of all, what is the law of the case in, can you identify that part of the opinion that actually makes some sort of legal holding that matter to the disposition that you consider to be controlling here?
Your Honor, this court in the first, in Harrison 1, affirmed the trial court's order in its entirety except for...
Except that it didn't, because it ended up reversing it. So what does it mean to affirm an order that you then reverse?
Your Honor, it was only reversed in terms of the leave to amend. And appellant today is relying...
Which means that so the order on appeal was a dismissal with prejudice. That was reversed. That means that the order didn't exist anymore. It was sent back to give the plaintiffs another opportunity to amend the complaint. That means that the only thing relevant to that disposition was the fact that the trial judge supposedly made some determinations as a matter of law that potentially were disputes of fact. That was the rationale for reversing. What's the rest of the law of the case? Like, how can an appellate court affirm something that it then reverses and have that be law of the case?
Your Honor, in Harrison 1, this court did not make a endorsement of any of appellant's proposed amendments. So
It also didn't endorse anything in the order specifically either.
Your Honor, even in that situation, Judge Marsh's order of dismissal, which is finding that that there's no claim here, and that the claims are barred by res judicata and collateral estoppel, those still stand because even when given the opportunity to amend their complaint, appellant did not meet the legal standard necessary. And that goes back to the fact that at the point where they were denied medical coverage in the administrative context, instead of following through with an appeal to this court in 2017, they decided to climb out of the administrative framework and bring suit in circuit court. And that really taints all of their claims today.
Is it the department's position that, yes, it should have been sued, and so it was properly named as a nominal party, but yes, then the trial court properly dismissed the department as a nominal party? Is that the department's position?
Your Honor, the department's position is that is because of that fundamental failure that appellant did not take advantage of the appeal at the administrative level, this claim that they're trying to bring in trial court in 2019 and again here.
But not against the department, against Blue Cross.
Right, but even then,
It wasn't
Your
a
Honor,
party, is a private entity.
who would
It's
not,
not subject to DOA and its jurisdiction in the executive branch.
but since Florida Blue acts as a privy with the department, Florida Blue is here as a third-party administrator. Florida Blue is only administrating the funds that are within the hands of the department. So for the department is involved in the sense that any money that's going out in these plans and these claims is from the department. So Florida Blue, as a third-party administrator, is within the wings of the department. Your Honor, I see that my time is about to, or is close to coming to an end, so if there aren't any further questions.
I have one.
Okay.
So this business about you don't exhaust, it's not exhaustion of administrative remedies unless you take an appeal under 12068. I know that this court has said it a couple times without any analysis, just cites the fourth ECA decision, the FHSAA opinion, which, by the way, didn't have to do with an agency. So what's the rationale behind that? How can a failure to invoke the judicial branch's power, how can that be part of the requirement that you exhaust administrative remedies? Since an appeal under 12068 invokes this court's authority under Article 5, Section 4, how is that an administrative aspect of it?
Your Honor, I think that goes back to how Florida law and Florida statutes preserve these questions that fall within the purview of agencies like the Department of Management Services. Because Florida statutes and Florida law reserves it that way, there's still a way for appellant to come to this court or come to a traditional court and appeal their claims, which here appellant failed to do so. And I think here what's the danger of allowing this to keep continuing on and on and on is that there's this precedent of maybe if we don't pursue appeal at the critical question of is there a proper denial of medical coverage, and instead repackage these claims in different flavors and bring them to a circuit court, we can survive the administrative framework and avoid judgment at the administrative level, and maybe perhaps get a different judgment at the trial level, get a second bite of the apple. In Your Honors, I see I have 30 seconds remaining, so.
It's actually 30 seconds, 43 seconds over now, but
Oh,
that's okay.
perfect.
You can conclude if you like.
Okay. If there are no further questions, Your Honors. Because Judge Marsh's orders met standards for consistency, fairness, and was supported by the record, and because appellant cannot support his current claims without relitigating the decided issue of coverage denial, we ask this court to affirm the trial court's decision and put this case to rest. Thank you.
Counsel. Why don't we add one more minute then to rebuttal?
Your Honors, I want to address one point on rebuttal, and that is, just like the briefing that we received on this issue of the dismissal of the class allegations, here today, appellee, the department has not addressed the fact that Judge Marsh dismissed all the class allegations, and the case that they rely on in their brief, the Mills case, stands for the same proposition of all the cases we've cited, which says it's improper. And Judge Marsh went even further when Your Honor's reviewed the order that Judge Marsh entered granting dismissal for the department. Not only did Judge Marsh say that we failed to prove commonality, typicality, the things that are required to be proved for class allegations, he found that we failed to prove them.
Are class allegations a separate count? Is that a separate form of relief? Or is there a procedural mechanism to make, which with roots in equity, to make the judgment effective virtually, I guess, across
That's a good question.
parties that aren't there, actually?
And Judge, having dealt with that on both the plaintiff and the defense side in class actions, sometimes they're pled together individually on behalf of the class in one count. Sometimes they're separated out. More often than not, they're separated out. We
Well,
had
the reason
7 count. Yes, sir.
I mean, but the reason for my question is look, I mean, the trial judge dismissed your Second Amendment complaint on some legal grounds.
Yes, sir.
We may agree with one or more of those legal grounds. If we do, what's the difference whether he also struck the class allegations?
The difference being, Your Honor, in those circumstances, what the courts say is that the party should be allowed to conduct discovery and allowed to find time, in given time, to find another class representative. So it would depend on what the legal basis was that
But
this
you're not
court was
precluded.
affirming.
You're not precluded from finding other another representative plaintiff
Oh, we most certainly would be, Your Honor, because the case is dismissed with prejudice.
against your client, the current client.
Yes, Your Honor.
That doesn't, because there wasn't any class determination, that can't have any effect on any other party.
Oh, it certainly.
Or a potential plaintiff.
The way it works, Your Honor, in this particular instance is it would have, right now, we filed a complaint that's been pending for a long time. We've had a couple of appeals. The class period that we'd be able to plead on behalf of this class that would or would not be subject to statute of limitations and those sorts of claims would be one set of statute of limitations in this case and one time period in this case. If the case is dismissed with prejudice and somebody 2 months from now filed a new class action, they wouldn't be able to go back as far, and all those individuals who would be subject to the class claims in this case would lose their rights.
That sounds like a concession that over or how many years this thing has been pending, that there's not been any work done to identify any other potential member of the class. I mean, that could have been done years ago.
Absolutely. We tried, Your Honor, and as Your Honor will note in the record, we've been denied any discovery because the trial court entered an order precluding any discovery in this case. So we haven't been able to conduct any discovery. But I would agree with Your Honor. Typically, that's what you'd be able to do.
But are you arguing contrary? There's a Florida Supreme Court case, Sosa, which I don't think anybody cited. There's a case that I relied on called Ahern that cited that. If you don't have a viable claim as class representative, you don't have a class. So why does all this class stuff matter if Harrison doesn't have a viable claim?
And I think Sosa and Ahern, and this is, that wasn't from this case, but I'm going off my memory, were more standing issues for the class representative and whether the class representative had an injury in fact.
They were picking off issues actually where the defendants came and picked off the class representative, and then could they still proceed with the case? But the main theory was you still had to have a cause of action as an individual to be able to proceed for the class.
Yes, Your Honor, and that's a standing issue, and we would assert and will argue in the next appeal this issue of standing and injury in fact. And part of the issue that we keep hearing is, and we just heard it with the rebuttal, I see that my time is concluding.
Sure.
May I
Go
answer
ahead.
the question and conclude? The argument that we heard from appellee just a moment ago is that we're making the same arguments we made in the administrative case and we're seeking the same relief. that is what the trial court found in its order, and yet it didn't cite to anywhere in the second amended complaint where we're doing that. We're not seeking the recovery of the denial of benefits. That's nowhere in the second amended complaint. But that's their theory that they continue to push in their argument that the trial court adopted without anywhere in the record stating that. So we have an injury of fact. They haven't served interrogatories, requests for production as to our pleading of damages, our general pleading of damages, where we could describe what we're pleading. But we're here on a motion to dismiss, and we haven't even gotten there.
Thank you, counsel.
Thank you, Your Honor.
We'll keep the bench. Thank you both, and allow the appellees to reset and proceed with our second argument then. Are they, y'all reset?
I'll give,
Need the appellees to reset.
Yes, yes, sir.
so, I'm not sure what you're asking me.
To switch seats, if you want to change.
Okay, well, okay.
I didn't know if anybody else was coming up to council table, was my only thing.
I'll just leave all my stuff over there. I wasn't sure what you were saying.
Daisy has all the stuff.
I wasn't demanding anybody to change seats. What I was asking was there anyone else coming up for the appellee that needed to come up to sit there? And they were welcome to do so. But however y'all want to arrange yourselves, that's not my doing. Okay, thank you. Okay. Are we both then ready to proceed on our second case?
Yes, Your Honor.
Thank you. So we'll go ahead then on Harrison versus Blue Cross and Blue Shield, 231676. And again, counsel, would you like to reserve some time for rebuttal on this case?
I will do my best to adhere to my request this time and would ask for 4 minutes for rebuttal, sir.
4 minutes on the case. Thank you. So noted.
May it please the court. Again, Michael Orr on behalf of the appellant. In understanding there are a number of issues in this case, we would like to address 2 points today. One, that the trial court incorrectly applied this court's prior opinion from Harrison 1 in its order of dismissal, and second, that the administrative proceeding does not act to preclude the claims under the legal doctrines of res judicata or collateral estoppel. As to the first argument, Your Honors, and Judge Tannenbaum was addressing this earlier with the prior appeal, we have this opinion that Judges Winokur and Jay and Thomas wrote, in both the state and the appellant requested clarification, and an opinion was substituted. And that clarification was meant to try to understand what are we doing when we go back. And with the opinion that we got, as Judge Tannenbaum noted, it said, we affirm without comment, except for, as we're discussing here, in finding that there should be reversible, or there was a reversible error here because there was no leave to amend granted. And there's a practical component to what that panel did with the opinion. They're not going to, no appellate court's going to prejudge legal arguments on a non-final order when the complaint is being amended, because under Florida law, once you amend the complaint, those claims are abandoned. And so what the appellate court was doing was saying, this is reversed, leave to amend should have been granted. But here's the significant piece from our vantage point that we believe has been lost. In that opinion, the court states its finding and says, one of its findings, that we further find a factual dispute existed which was not appropriately raised or resolved on a motion to dismiss. And they say, we further find that appellant's proposed amendments are not futile. Footnote. And then we have footnote 2. The argument from Florida Blue in their brief is that what follows in footnote 2 from that panel is all dicta. And Your Honors, our position is Judges Winokur, Jay, and Thomas did not write that entire footnote explaining their holding with citations to case law and the arguments to give dicta. They were providing the analysis and the basis for their ruling.
Well, let me make another suggestion. Perhaps it's not dicta, but perhaps it relates only to the bad faith claim, which was asserted in the First Amendment complaint, but not in the Second Amendment complaint. They start, we note, with regard to appellant's bad faith claim, and then go on to the rest of the paragraph. So how do we know that this, or how should we read this such that it relates to more than just the bad faith claim?
In Your Honor, the way I read it, I believe that's the first sentence of the footnote, and then what they've essentially done in that footnote is address the arguments that Florida Blue was making, one of which, a significant argument that they've made again to the trial judge, and the trial judge adopted in its order of dismissal that Florida Blue provided, is that because they are a third-party administrator and not an insurer, that they have no duty to the appellant or to policyholders, state employees. The judges, the panel from that Harrison 1 opinion expressly rejected that and said it's too early to make that determination at the pleading stage, and pointed to the allegations from our complaint, which exist in the Second Amended complaint, that there's an agreement between the state and Florida Blue that in a particular time period, a given year, if they pay out claims over and above a certain percentage, I believe it's 105% of what's taken in for premiums, that Florida Blue is on the hook for that. And so what the court said in that footnote is this determination that there's no duty owed to the policyholder, to Harrison, it was too early and should not have been resolved on a motion to dismiss.
But, I mean, duty, though I don't believe, and it's a long footnote, but except in the parenthetical with Cole, I don't think the word duty appears, right?
That's correct, Your Honor. It says, what they say is a factual dispute existed which was not appropriately raised or resolved on a motion to dismiss. And so they specifically found that this argument from Florida Blue that it's just an administrator, not an insurer, should be rejected.
What do we need on the duty issue, not even with the law of the case, but if we're just looking at the duty issue fresh, what do we need more besides 110, 1235, and the attached plan that's part of the record here? What else do we need to determine whether a duty exists?
I think if the court, the trial court, were to accept the well-pled allegations of the complaint, there is no more that's needed to find that there's a duty. But understanding that duty is a legal issue and the court can determine it, that's typically something that's determined on summary judgment. In this particular instance, we would like to have discovery as to the relationship between the state and Florida Blue and that contract, and what the actual inner workings are and responsibilities are, in accord with our allegations that Florida Blue takes on a lot more responsibility and does a lot more than perhaps just the plan suggests that they do.
But how is that relevant? I mean, what the relationship is between Florida Blue and the state, or what the contractual relationship is between the two. Where's the contract relationship between your client and the state, or between your client and Florida Blue?
And I think it's in the record somewhere around 995 or 998.
I'm just relying on your complaint. I mean, I'm looking at the Second Amendment complaint, and I'm looking at the attachments. So
Yes.
where, and then maybe start with the first couple pages. What was it? Record page 998. If you can explain explain how you get around the statement on that page that Florida Blue is exactly what it says it is, and which is in your complaint, that it is a third-party administrator. It doesn't make any final decisions about claims, coverage, benefits, anything. That is ultimately, finally, and exclusively the realm of the Department of Management Services, DSGI.
And our allegations, Your Honor, are such that even though the plan booklet states that, in reality,
And
what
the statute
happens.
says that as well, yeah.
I'm sorry, Your Honor?
And plus the statute.
Yes, sir. And despite the fact that they say that, our allegation is that in practice, what happens is a state employee has a choice between several plans that they can choose from. They can choose a plan, in this particular instance, the PPO plan with Florida Blue. They get a card from Florida Blue. They're told that they can contact Florida Blue. Their plan, for all intents and purposes, is a Florida Blue plan, and all their communication is with Florida Blue. Florida Blue is the one denying and making decisions. Now, from that point, the argument on the other side is, well, now we're just an administrator, because that's all that stuff really is. We're just an administrator, we're not an insurer. And that's what they've been arguing and argued on the first appeal. And what we said is that's not the case. We're arguing in the alternative that you are an insurer because under your agreement, your contract that you have with the state, you have obligations to pay out of your own funds for claims, for benefits, after a certain percentage. And so despite what the statute says.
That's not really the definition of insured, though. I mean, that's not the same as accepting risk and having, capital back that up. That's pursuant to an administrative agreement between the state and Florida Blue, pursuant to statute that requires all of this. I still don't see when the statute says that these are TPAs and TPAs alone, and that the state, and it's coming out of sovereign funds at the end of the day, and that it's the state that's the ultimate determiner of these benefits. How does that change? How can you change the relationship by argument what the statute says expressly? And the documents attached to your complaint say expressly.
Absolutely, Judge, and quite frankly, it happens all the time in litigation where a statute provides for one thing as to how things are supposed to happen, and then in practice or reality, they're done a different way. And so that's what we're suing over. We're suing and saying
You're
that
suing
Florida
to change
Blue.
the meaning of the statute? Or
No,
you're
sir.
suing to ignore the statute and say there's this other theory?
No, sir. What we're suing and arguing is that exactly how the prior panel of this court analyzed in its footnote, that it's too early at the pleading stage on a motion to dismiss to determine whether or not the relationship between the parties is such that Florida Blue is not an insurer in this scenario and is only a third-party administrator. And so that's our argument on appeal here. What the trial court did when it entered its order of dismissal, the trial court expressly ignored that entire paragraph. Doesn't address it anywhere in the order. Doesn't address the finding from this prior panel as to those issues. Completely ignores it.
Was that footnote necessary for the disposition?
Absolutely, from the standpoint that it provides the analysis for the holding that the court provided.
But the court didn't remand and say reinstate the First Amendment complaint that had been dismissed. It said the error was it was dismissal with prejudice, that the trial court abused its discretion. That was the error. It abused its discretion in not allowing you to amend your complaint at request.
Yes, Your Honor. And as to this footnote, what the actual sentence, the holding was, is further we find that the proposed amendments from the appellant were not futile. So that's why it's very important that the court explain what the amendments are, what the claims are that are not futile. That's what the analysis is in the footnote. These are the claims that should not have been decided at the motion to dismiss stage, which is exactly what the court did
Well, so
when it went back
what
down.
did we affirm? Because I've got the original order here somewhere. What out of that original order on the first amended motion to dismiss, or the motion to dismiss the first amended complaint, what did we affirm without comment the trial court's order?
There were arguments that related to the state when there were other claims against the state that were affirmed. The arguments that were not addressed in the footnote and the analysis from the prior panel. The sentence that Your Honor read from the very first line of the footnote, the insurer bad faith count. All of those things that are not found in the second amended complaint is what was affirmed. Now, I know that the motions for clarification that resulted in that substituted opinion. This issue that we're all arguing over here today, and much of what your honors will see in the transcript on the hearing on the motions to dismiss, was trying to discern just that, Judge Bilbrey. We were all trying to discern what
One of
was
the
it.
things- And I found in my stack of papers here, I found the order on the motion dismissing the First Amendment complaint. One of the things there was, or I guess two of the things, res judicata and collateral estoppel, which is not mentioned anywhere in our opinion. So did not then the Harrison 1 opinion affirm the findings of res judicata and collateral estoppel from the trial court on the First Amendment complaint?
We would suggest they didn't, Your Honor, only because, and this touches on what Judge Tannenbaum said earlier, and I'll give an analogy. When a court PCAs an opinion or an order, there's no precedential value there. There's no analysis
That's different
addressing.
than the law of the case. If
That's true.
I mean, the case is for, whatever the trial court did, if we said, yep, we affirm that, that's locked in unless you're trying to show a manifest injustice, which is not alleged here. So, what we affirmed, whatever that was, if anything, is locked in, right? So I don't think the PCA analogy, which I understand what you're trying to say, but I don't think that's analogous.
And Your Honor beat me to my second sentence, which is the only difference is when you have an affirmance without comment or an affirmance without analysis, that it can be law of the case and there can be an argument that relates to res judicata as to certain issues. But
Can a PCA affirm trial court findings in an order of dismissal with prejudice?
I think
What is that?
that's a great question, Judge. My understanding is the District Court of Appeal, if it was writing an opinion and specifically detailing what findings it was affirming, perhaps it could do that. But generally speaking, it's affirming a judgment, an order, a decision of the court, or reversing that decision of the court, and with or without analysis. And so in this particular instance, it's not like we're all here with an order from Harrison 1 or an opinion from Harrison 1 where they go through each finding of fact of the 30-some-odd legal arguments that are in the motions to dismiss and says we agree with these and don't agree with these. And that's frankly, again, because, as Your Honors noted, Judge Tannenbaum, this was a non-final order where they just said you should have allowed leave to amend. And by the way, the proposed amendments, which are in our brief, we pointed out were not futile. And that's what the appellate court was addressing in Harrison 1. You should have allowed amendment. And I recognize that we have this affirmance that muddies the water because now we're arguing what did we affirm or not affirm. And our whole argument on that, Judge Bilbrey, is there'd be no point to reverse the case and allow amendment if it was just going to be affirmance as to res judicata and collateral estoppel, because there would be no claim. And I see that my time's
Thank you, and we'll give you
about up.
4 minutes for rebuttal then. Thank you.
Thank you, Judge.
And we'll add 4 minutes to the appellee side also. Apologize again for the seating confusion. I thought there's more folks would be coming up.
It's just me, Judge.
That's okay. We'll have questions for you anyway.
May it please the court, I'm Tim Connor from Holland and Knight. I'm here representing Blue Cross Blue Shield of Florida. And as I've listened to the questions from the panel today, obviously there's a number of questions, a lot of issues in the case, and it's kind of hard to just try to put a bow on everything in this case, but I'm going to try my best to do that. So, as Your Honors know, there's a long history to the case. There was an appeal process. There was an administrative law judge hearing. There was an evidentiary hearing. The conclusion of that entire process was that the plaintiff's claim for benefits was properly denied. So now we find ourselves in circuit court dealing with what is essentially a challenge, a collateral challenge to that issue. Let me start off by talking a little bit about the law of the case, because that is one of our principal arguments, and we believe that is a really important argument here. And as some of the questions that you've asked have elucidated on this issue, we're looking at what was the first order of dismissal. This is the Judge Dotson order. And what was the opinion of this court with respect to that order, and how do those two things relate to each other? And then how does that relate to the entirety of the case? So I think if you look at what this court did previously, and I believe that, when you look at court opinions, you look at what is the holding. Obviously, we've argued the footnote is dicta, which is what we believe. But the words that are used should be given their plain meaning. And they're not words that I think in this instance are wasted in any way.
Was there
So-
anywhere in the opinion, did it say, as to counts, fill in the blank, 1, 3, and 5, the dismissal with prejudice is affirmed, and as to the remaining counts, we reverse with the direction of the trial court to allow an amended complaint? Was that said anywhere in the-
There are no words like that,
Right.
but,
Would that not have been a better way to accomplish
well.
what now you're trying to take advantage of as law of the
No.
case?
Well, no, Your Honor. I think the words are straightforward. Now, I'm not in the business of telling the appellate court how to write a better opinion. But if you look at the words beginning in the bottom of the first full paragraph, this court says, "We affirm, without further comment, the trial court's order with one exception regarding the trial court's implicit denial of appellant's motion for leave to amend. We reverse and remand for further proceedings consistent with this opinion." So what I take that to mean is that this court agreed with what Judge Dotson did substantively in his rulings on res judicata, collateral estoppel, and the other issues that are outlined in that order, except Judge Dotson did not grant leave to amend. Now, the leave to amend was not a motion for leave to amend. It was a statement in another paper, and there was no proposed amended complaint. So that was one of the things that we argued about a little bit when we were arguing about the motion for clarification, because there was no proposed amended complaint, and it's something that we pointed out in our papers. You don't know when we go back, is there going to be something that's viable or not? The futility doctrine, which is referenced, is obviously a doctrine that's been around for a long time, and which basically says, look, we're going to give people a chance to amend unless we conclude without any doubt that it is impossible to amend. So we're going to at least give you that chance. And the plaintiff had not abused the opportunity to amend, and there was no finding by Judge Dotson of futility. So that just wasn't there. And this court said, look, we don't think it's futile, okay? But in the footnote that we've talked about, the court said, and this is at the very end of the footnote, to this end, appellant should have the opportunity to attempt to amend the complaint as to all claims against all defendants. However, while any amended complaint must adhere to this court's opinion, we do not conclude that appellant can state any particular cause of action. So, in my reading of that opinion, I believe that it's straightforward. I believe that what this court did is it agreed with the substance of what Judge Dotson said in his order. On the procedural issue of should there have been a right to amend, this court said, we think the opportunity should be given, not summarily denied as it was in this instance. And we will send it back for that purpose. The plaintiff is free to amend it as to all claims, all defendants, however it wishes to do it.
That seems to cut against, so what you're arguing is that, well, this court affirmed, whatever Judge Dotson's reasoning was in his original order. But then it says, but they can amend their complaint as to all the counts, which
Sure.
means that what he said really didn't. I just, how do you reconcile? That just seems terribly inconsistent.
I don't think it's
Or
inconsistent.
not to say
at
that
all.
you're being inconsistent, how do you reconcile those two
So,
ideas?
well,
Unless-
the way I reconcile it is that substantively, this court was agreeing with what Judge Dotson had done, but on a procedural issue, the futility issue had not been addressed by the trial court. This court was not willing to say it's futile. Therefore, we're going to give the opportunity. Now, that doesn't mean you go back with a clean slate as if nothing ever happened. That doesn't mean you go back to the trial court and the issues of res judicata, collateral estoppel, lack of standing, et cetera, that were in Judge Dotson's order go out the window.
But
It
at least
means
it's-
you take them into account when you do the amended, I'm sorry. Your Honor.
No, but at least as to the breach of contract action, if we're saying the collateral estoppel and res judicata are still there, but they can amend, we said in the opinion, amend on all claims and against all defendants. Like Judge Tannenbaum was saying, that just seems inconsistent. How can you go back, at least on those counts, which were allegedly, previously adjudicated in the administrative action? It just seems like we've created some kind of inconsistency there.
Well, I mean, look, I agree that it is difficult to go back and amend the complaint to get around some of these issues, and that's why we're here today, because that wasn't able to happen. But we have significant legal issues that bar these claims, whether we're looking at Judge Dotson's order or the current order under review. I'm not here to tell you that the plaintiff could amend the complaint because, frankly, I don't think that they could. I don't think there's a viable claim in the case, period. But that's my opinion as the lawyer for Florida Blue in this case. And so I think that this court was saying give the opportunity, but there's no guarantee that you're going to be able to state a cause of action.
Did Florida Blue participate in the DOA proceeding?
Yes. Yes,
a
Florida Blue
party?
did actively participate, Your Honor. So
Was it a party?
it was not a named party, but it was, and
So it
and
wasn't
this,
a nominal party?
it was not a nominal party either. So, in this context, Judge, the way the statute, you've asked questions and you've obviously read the statute and the plan, and I think it's pretty straightforward. But, the way the administrative proceedings work, it's an evidentiary proceeding. A lot of the evidence has to come from Florida Blue because Florida Blue is the third-party administrator. So the questions are, well, what did you, Florida Blue, what did you do? How did you handle this claim? How did you come to the decision you came to on that level 1 appeal that they're responsible for? And so if
The reason
Yeah.
the reason I'm asking is the same question I asked your other counsel for the department. How is it that an administrative hearing officer in the executive branch can issue an order that can bind in some way the judicial power of the state in a court of law?
So,
Without the legislature specifying something
yeah, so
otherwise? Or, I mean, to put it to address it from both directions, why is that not actually some sort of sovereign immunity issue or something else? Like if this is, or an unauthorized lawsuit against Florida Blue in some way?
Yeah, so I think that comes out in our argument, Judge, about exhaustion of administrative remedies, that the legislature passed this statute specifically to create the plan, and as part of that said there will be this administrative process. And that process is the exclusive process for resolving disputes about whether the claim should be covered or not. So I think it's intertwined with that issue. And we've argued in our papers, and we argued below, that there was a failure to exhaust administrative remedies, because after the ALJ's decision is adopted by the Department of Management Services, the only thing that we believe the plaintiff could do here is appeal to this court.
But even if, let's say they did that, and I still don't understand how the exercise judicial power can be part of the administrative process, but let's assume that they did take the appeal.
Yeah.
And it was affirmed. So now they've exhausted their administrative remedies and now they can sue?
No.
Right. The answer is no, because
Yeah.
what the first thing you said, which is it's a public right established by the legislature. You can only sue the legislature or sue the state or proceed against the state in the way that the legislature directs, and the only way the legislature is directed is through the administrative process. That's the only route that they can proceed against or through to seek relief. And they did that. Regardless of whether they took the appeal or didn't take the appeal, it doesn't seem to be an exhaustion issue. It seems more to have to do with the fact that there's not a legal cause of action for relief against Florida Blue under these scenarios with the documents that were attached to the statute that's present.
Yes, sir. I would answer that. Number one, I agree with that. I don't think there is a claim against Florida Blue that can be made outside of that administrative proceeding with respect to the state group plan and how claims are administered under that plan. That's number one. Number two, I think the fundamental principle that you're raising is what we raised within our argument about the failure to exhaust. So it maybe is expressed a little differently than Your Honor might express it, but I think the principle is the same. You can't bring a suit in circuit court over these issues because your remedy is over here in the administrative context.
I mean, I think this court recently addressed this issue, at least a little bit in Wester, if I'm not mistaken. And I don't know how much you read that or like whether this has any effect, but that's where I'm having trouble understanding why we keep talking about exhaustion, as opposed to whether there's a viable theory of relief against Florida Blue in the first place.
Yeah, well, I think the answer is there is not a viable theory, and maybe
I mean, presumably there's not a viable, there's certainly no statutory basis to proceed. The legislature has not set out a vehicle by which to seek a public right against Florida Blue in circuit court, which would leave presumably some just common law theory, which I think is all they've been proceeding against in the Second Amendment complaint. So
Well,
then what's the question, why can't we address that question, whether there's a common law theory that they can pursue against Florida Blue?
Yeah, well, I think at the end of the day, if you talk about what it is that is actually being achieved by a claim that's being made, it has to be that our claim was wrongfully denied. So the claim for the residential treatment in this case was wrongfully denied, and that decision has already been made. So if the decision was, that claim should have been paid, ultimately the funds come from state tax dollars in any event. So I think, we've made these arguments about the failure to state a claim and that there is no claim, et cetera, for a variety of reasons. And maybe the argument is a little bit different than maybe the way Your Honor might express it. But I think we get to the same point of saying there's not a viable claim here, either way.
I mean, there could be, I mean, I'm not saying there are, but in hypothetically, in the realm of common law actions, there could be some tort theory to proceed against Florida Blue. I mean, let's say Florida Blue negligently misrepresented something about how this process works, and it caused them to rely on it, just you walk through the elements of that. Or let's say that Florida Blue behind the scenes is tortuously interfering or doing something to interfere with their effort to get a public right. I mean, in theory, that could exist, right? I'm not saying, you're not conceding it, I mean, just it's not necessarily foreclosed just because this has to do with a claim under insurance that's already been denied through the administrative process. It may be they haven't expressed it in their second amendment complaint. Those are two different things.
So, I'm hesitant to say, hypothetically speaking, there could be a claim, because I think the answer to that question is no. Is there a set of facts that I'm not aware of where, possibly there could be a claim? I don't know the answer to that. I don't know exactly how to answer that other than analyzing the facts that are in front of me. So I don't want to concede that there would be some basis for a claim. I just know that in this case, there's not.
Right. I mean, on these allegations,
Yes.
maybe, I mean, I guess that's your argument.
Yes.
And this is their second amendment complaint, so it's not like they haven't had chances to assert these other theories. So I'm not asking you to give anything away. I'm just conceptually, is the focus still, the statutory avenue, the public right to get some sort of benefit from the state treasury, which the legislature controls, or is it some common law theory where they're coming after Florida Blue and its pockets, independent of the state treasury?
Yeah. Well, I don't think that is this case. And I think that a number of our arguments actually, sort of deal with why that's not in this case. So if I don't know if I need to address the trial court exercising independent judgment here. You've talked about that, and there's been a number of, I think absolutely Judge Marsh exercised independent judgment here.
Well, I mean, does that even matter?
I was going to say, Your Honor, first of all, I think he absolutely did. I think there's no question about that. But I think secondly, I don't know that it matters that much, because if you agree with the decision, then, you should affirm. And the legal explanations that are laid out in his decision, I think, are straightforward and should be affirmed. If you disagree with the decision and you think that he's absolutely wrong about these issues, then, presumably you would send it back and say, we think you were wrong. So I don't know that it necessarily matters when you get right down to it. As you said, he could have entered an order just saying motion granted without explanation, and then we would be here arguing about all of the reasons that were raised below that could be the basis for the decision. And it's, I'm running out of time to address my other arguments. So I have obviously a number of things that I want to get to, but I see that I'm out of time. So I just want to conclude by suggesting this. We think that all of the arguments that are set out in our brief are very straightforward arguments about this case, and whether it's a law of the case issue or there's confusion about what happened the first time around, and you go to, okay, well, if law of the case wasn't there, how do we deal with the other issues? And we've addressed that in our brief. There are 5 things that I think you should look at. The first one is the first trial court order. The second one is obviously the first opinion here. The third one is the actual second amended complaint. I think you should lay that against the administrative law judge's decision and look at the findings, because all of those take out each of those findings in that second amended complaint. So they've already been adjudicated. And then finally, obviously, Judge Marsh's order here, which we think is correct and should be affirmed. Thank you for the extra time.
Thank you, counsel.
May it please the court. I want to address the question that Judge Tannenbaum raised to counsel about, well, couldn't the plaintiff in this case, the appellant, have a common law claim against Florida Blue? Not prejudging whether they've pled it right or not in this particular instance, but would they have one? And the answer from counsel was no, but there was no explanation, and there's no explanation anywhere in the brief. And there was no explanation from the trial court below. The fact remains that a class claim, negligence, negligent misrepresentation, an injunctive relief claim, none of those claims can be filed in the administrative case. None of those issues can be resolved by an administrative law judge. And in fact, yes, sir.
I agree with you. What do we look to? A lot of those, though, presuppose a duty, right? You got to have a duty as an element of, negligence at least. Where do we look to besides the operative statute and the plan to find whether a duty arose to your client from Blue Cross Blue Shield?
Your Honor, the well-pled allegations of the second amended complaint, where we describe at the beginning of the complaint the relationship between the appellant and Florida Blue and what the relationship was there. And I believe it was either the Hotchkiss or the Cole case where the court said dealing with that issue on a motion to dismiss was premature. So it's our position, Your Honor, that we've pled that there is a duty based on the relationship, based on the fact that they are an insured. They're effectively making health care decisions. A number of state employees that would be members of this class, there are varying levels of pay certainly for state employees, but the ability to have an approval of a health care decision and have a claim approved or denied for many people is effectively a decision on whether you're going to get the health care treatment that your doctor's recommending. So we've pled in this particular instance that there's a duty owed to administer the claim fairly, to follow the plan, to follow the statute, and not to use undisclosed information or criteria. And that, we believe, is critical. We're not suing, and
But
this
they're
is...
ultimately not responsible for that. That is by statute, that is the Division of State Group Insurance that is ultimately responsible for all those decisions that Florida Blue may be making that, your client, others may not like, but that's ultimately the state that's responsible for that.
Ultimately, the state is responsible and is the final arbiter and gets the final decision-making, and that's why the administrative process involved the state as a party. Your Honor's correct. And so the way it worked is the claim gets submitted to Florida Blue. Florida Blue denies it.
Right.
Florida Blue, there's an appeal to Florida Blue. Florida Blue responds again and is relying on criterion information outside of the plan, outside of what was agreed to, the benefit of the bargain. When our client chose
Well, wait,
the
what's the
PPO,
bargain? What's the bargain?
paid a policy premium for a PPO plan with Florida Blue. And
Well,
so
that's by state, that's a directive from the legislature as a state employee. The deal is that the state's going to pay most of your premium. It's not even a premium. The state's going to cover your claim, and there's an expectation that the employee is going to cover some of that cost through a holdback in their pay. It's
And
not
so-
quite the same thing as paying a premium to a private insurer.
And so I'd point out, Your Honor, we're here on a motion to dismiss stage. All of these things are not even in the record at this point. What we
But they
have...
are in the statute. That's why I keep asking about the statute. You can't get around the statute. If it says it's X, You can't say, well, but it might be Y. It is just X, because that's what the statute says.
And that would be more appropriate for an affirmative defense and then a motion for judgment on the pleadings or motion for summary judgment, and not a motion to dismiss that's confined to the four corners of the complaint. And looking at I see that my time's about to expire. May I
Go ahead and
respond?
conclude for us. Thank you.
Your Honors, the motion to dismiss that, and the order, corresponding order from Florida Blue in this case, and the order that was striking class allegations, both of which were unedited, relied upon statements and argument, and we've set it out in the brief, that were expressly rejected in Harrison 1. And on top of that, the court states that we're seeking the same relief from the administrative case, which is we're seeking the denial of benefits. I want to make abundantly clear to the court, a review of the second amended complaint, nowhere in there do we say we are seeking the denial of benefits. We are seeking the amount for the medical treatment, which is what they've argued and what the trial courts adopted without citation to anything in the second amended complaint. And that's the problem with these orders. They go outside the second amended complaint and the well-pled allegations, and they rely on issues, argument, and evidence outside the pleadings. This court should reverse and should direct Florida Blue to answer the complaint. Thank you, Your
Thank
Honors.
you, counsel. Thank you both for the arguments. We are adjourned.
All rise.